One founder, John Adams, a signer of the Declaration, had suggested that our Constitution was made for a religious and moral people, wholly unsuitable for any other. However, during the decade preceding the pandemic, the churches had been in a sharp decline, falling in membership by as high as 12% over the past decade, and post-pandemic, the churches have lost even more, 6%, or half the losses that had been experienced over the prior decade, so that today, causing for some reason for boast, while for others some trepidation. But fundamentally are the words and thoughts of John Adams, for a living document, as some have described, of any particular relevance and importance, today. That was then, and this is now. Does anything last forever? What do you think? We'd like to know.
This is something about which, at least, a thinking person should dedicate some considered thought. Our Constitution was made for a religious and moral people, wholly unsuitable for any other. What do you think? We'd like to know. Will that government of the people, by the people and for the people ever perish from the earth? Does it pose a danger greater than even melting polar caps, greenhouse gases, pandemic viruses, war, famine, international trade agreements, taxation or even voting? We have often heard that democracy is at stake. What do you think? We'd like to know. Taking this discussion to an even higher level of consciousness, consider this, according to the Civil Rights Act, not of 1964, but 1866, codified at 42 U.S.C. Section 1981, c. The rights protected by this section are protected against impairment by non-governmental discrimination and impairment under color of state law. And defining these civil rights, the Republican Congress, almost immediately after the Civil War, had deliberated and decided that all persons within the jurisdiction of the United States shall have the same right in every state and territory, meaning simply that, when it came to civil rights, regardless of where you resided or traveled to within the boundaries of the United States, whether you were even a citizen or not, you would have the protection and power of the federal government to ensure your right to make and enforce contracts, to sue, be parties, and to give evidence. Simply, whether you are engaged in transactions in commerce, or seeking redress before the courts, as long as you are simply just a person, you enjoy, as a civil right, equal protection under the law. What do you think? We'd like to know. And further, as a protected civil right, any person would have the right to the full and equal benefit of all laws and proceedings for the security of persons and property, for which, at least generally, no persons were to be considered, under the law, more secure in protection of their property or person, however, not in just some vague and general sense, but as measured by a specific unwavering standard of those enumerated rights and privileges, with regard to property, expressly as is enjoyed by white citizens, certainly a phrase and measure of contemporaneous significance, acknowledging that at least those property rights of white citizens may have had at least previously a more elevated status, but that standard has remained unchanged in the law, the threshold standard today, and nothing, at least in the law, has changed since 1866. What do you think? We'd like to know. And when one considers the history of the civil rights movement in the courts that, under Article 3, have been established to decide cases and controversies for all persons, cases such as Plessy v. Ferguson, decided in 1896, and arising under the nexus between transactions for railway travel and a Louisiana statute that had required railway companies carrying passengers in their coaches in that state, to provide equal, but separate, accommodations for the white and colored races, which had been later extended to other public accommodations, such as seating on public transportation, integration of dining facilities, such as lunch counters, and even desegregation in education, suits for which even persons like Reverend Oliver Brown had not been denied a right to standing or to file a suit in the courts, presenting powerful images, preserved in timeless monochrome photographs, certainly familiar to social justice ministers, progressive judicial activists and most civil rights organizations. What do you think? We'd like to know. Yet, within the present contentious politics, in which the nation, since the decision by the U.S. Supreme Court in Dobbs v. Jackson Women's Health Organization, many have raised a privilege of entitlement to protection of their bodies and their choice, which might be construed as a civil right entitled to equal protection of the law under the Civil Rights Act of 1866, which has guaranteed a right to the full and equal benefit of all laws and proceedings for the security of persons. However, those opposed to the decision have taken issue with the description of a fetus, to which abortion supporters have designated merely as their property, and within the context of Civil Rights Act of 1864, they have essentially staked their claim in an entitlement to property rights to be exercised and enjoyed with the same protections as enjoyed by white citizens, a position that denies that a fetus, which certainly even science presents an expectancy as much as a virus, is at all even a person-like entity, similar to the recognized property-like rights that have been afforded even to food stamps and other government entitlements, a continuing battle on civil rights that continues even today in the wake of the Dobbs decision. What do you think? We'd like to know. And, of course, in complementary provisions for those accorded civil rights, under the Civil Rights Act of 1864, in turn, those persons, not just citizens, are entitled to the enjoyment of those rights and privileges would correspondingly be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. What do you think? We'd like to know. However, under the Civil Rights Act of 1866, it is at least ironic that Justice Thomas has only now come under fire most recently, as not only an opponent to those who support abortion, but also for his raising the arguments regarding equal protection, not an expressly granted right under the Due Process Clause of the Fifth Amendment, as it is expressly a clause pertaining to state rights, under the 14th Amendment. What do you think? We'd like to know. And, within the context of the Civil Rights Act of 1866, it is even more poignant to note that, under the plain word meaning of the statute, those supporting their right to an abortion are stating essentially that they are entitled to have for their property the same protections of the government as is enjoyed by white citizens, while Justice Thomas, arguably a person who ain't really black, has been framed in the public mind as denying a right for persons of color to exercise a freedom to dispose of their property as they see fit and appropriate. What do you think? We'd like to know. And, in the modern era, several court precedents, primarily advanced in progressive courts, have, giving a liberal construction, have sought to enlarge the definition of property, which today includes a property-like right found in government welfare benefit and other entitlements, as well as a right to due process before termination of government employment, at least where such might deprive a person of his or her profession, and warranting a right to due process, in the form of some hearing before any government deprivation thereof, and while the degree and manner of proceedings may not be equivalent for all deprivations of these expanded property-like rights, courts have stated, rather ambiguously, that in this context, due process is the process that is due, as appropriate on for the particulars of those circumstances. Or perhaps you had never taken the time to consider how that all worked, relying only upon your mere beliefs. What do you think? We'd like to know.
This message was approved by Major Mike Webb. Honest.